now calling City of Contempt versus Amber McHenry, case number 24 TRD 819.
Ma'am?
I'm sorry. I'm just trying to get my stuff situated so it's right here.
Take a seat
I have a
in
question.
this blue chair.
Do I have
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down!
there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges
I object.
filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea.
Okay, so you tell me how you would like the plea: guilty, not guilty, or no contest.
First, I have to correct the standing, which is I am not the ens legis non degear. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case. I have sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand. I
will set this case for a bench trial, and we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case. But then, because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Involuntary can't be violated, basically, is what it means. So I have the right to a jury by trial.
No, you don't.
Of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they'll give you a trial date. Okay? So
then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis non degear. I told you
I don't know what that means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So,
great.
Yeah.
So
ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know
You're looking at the contract. you're looking at, the one who's going to be able to, has the authority to be able to put you in jail and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee, and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
you are not the beneficiary, and nor am I the trustee.
Yes.
Yeah, that's just not how it works, man. Not how it works. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Is this your phone?
This is 2424448SM, the People versus Eric Martin. Mr. Martin, can you tell me your name?
I'm a Roman cystic if that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, a defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over me. Why I don't want to take it, but
so no.
I get it kind of French too, because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin. And on that case, the complainant is Kirk Martin. There was a no contact provision. And that was one of the conditions of bond. And there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home. And the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him. And that you were taken into custody for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time, but they're serious allegations in violation and no contact provision. So do you want me to enter a plea, or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute?
This case clearly shows how the court follows legal procedure over personal arguments or sovereign citizen claims. Despite repeated objections from the defendant, the judge remains focused on explaining charges, rights, and moving the case forward under the law.
Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing, and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify you of crimes. Before I get to that, I want to notify you of crimes committed against me in the jail here since I've been here, such as criminal harassment, in
Okay.
violation of
I'm going to enter a not guilty plea on your behalf.
I'm not done talking.
Because your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I demand to be dismissed. Now.
Right. So, sir, you have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that lawyer appointed at public expense if you are unable to afford an attorney, and it's always possible that if the court determines you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation. If you are in custody, we must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is basis for separate criminal prosecution, I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing, or to be present to present evidence, to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them.
In these courtroom cases, defendants repeatedly challenged the court's authority writing instead of following standard legal procedure. In the first case, a woman questioned the judge's jurisdiction and used sovereign citizen-style arguments, refusing to enter a clear plea. The judge stayed focused on explaining the charges, legal rights, and available plea options before scheduling the case for trial. In the second case, a man accused of violating bond conditions argued that his constitutional rights were being ignored. Despite interruptions and objections, the judge continued to explain his rights, entered a not guilty plea on his behalf, and outlined the legal process moving forward. These cases show how courts prioritize legal procedure over personal beliefs or unconventional legal claims. Judges are responsible for maintaining order, ensuring defendants understand their rights, and keeping the courtroom process moving according to the law.
They're moving forward with it. It's already a malicious prosecution on the prosecutor's part. There's no probable cause because there's no evidence here. Bottom line, we don't know what happened. This is violating my due process rights. I'm being deprived of my freedom to be at the house I've been living at for 32 years. The bond order was legally should have never been ordered because it's based on, once again, an unsupported lying allegation that has no video evidence, no real evidence to support it. The bond order must be dismissed. I'm supposed to be allowed to go back home where I have a right to be. Doesn't matter how many lies are told.
Let me tell you your bond conditions, Mr. Martin. You're to appear in court as directed. All right, I'll mute you and read them, whether you like them or not. These are your conditions, sir. So I'll just read them into the record and you can choose to listen or not listen. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Whether you like it or not, you're not to have any contact with Kirk Martin or the residence where he resides and where this original allegation occurred, which is 9074 Clippert in the city of Taylor. Sir, you cannot purchase or consume alcohol or illegal drugs. You can't possess or have access to firearms. And you have a $2,000 cash bond. I've noted on the file that you're entitled to this hearing forthwith, so the clerks will give you a date forthwith. And we're all set.
The video also highlights the limits of courtroom behavior. When a defendant refuses to follow instructions or repeatedly interrupts proceedings, the judge is empowered to enforce order through contempt or custody to ensure the hearing continues properly.